The law tends to be quite permissive when it comes to formal requirements for contracts. Specifically, most contracts are enforceable, even if they are only oral contracts without any written documents. Of course, in terms of proving that there is a contract, it is always better to have some type of written evidence, such as an email, Twitter, regular mail, online chatting, etc. But the point is that legally speaking, the written form is by default not a requirement. However, there is an important exception to this. Many U.S. states have a positive law in place, known as the Statute of Frauds, that specifically requires that a contract be in writing in order to be enforceable. The goal is to increase legal certainty. The Statute of Frauds writing requirement is informal in the sense that any type of writing is allowed as long as it is in a permanent form. It may also consist of several writings as long as they clearly relate to one another. The writing must identify the material terms of the contract and be signed by the party who is being sued for contract enforcement, that is, the defendant. Although the Statute of Frauds does not require that both parties sign the writing, it is safer to have them both sign, since you do not always know who will turn out to be the defendant. In most states, the types of contracts that must be in writing in order to be enforceable are as follows. Contracts made in consideration of marriage, that is, prenuptial agreements, must be in writing. Contracts that cannot possibly be performed within 1 year from date of contract formation must also be in writing. Judicial authority is split regarding whether contracts for lifetime employment must be in writing. Contracts for the sale of land, including houses and buildings, and long-term leases over 1 year must be in writing as well. Contracts for the sale of goods, that is, tangible, movable items of personal property, in the total amount of $5,000 or more must also be in writing. Finally, a promise made by a person, a surety, to pay the debt of another person if that person does not pay, must be in writing. Another rule pertaining to formal requirements is the parole evidence rule. The parole evidence rule is the opposite of the Statute of Frauds. This rule comes into play when there is a written contract. The rule provides that when a complete written contract exists, then prior and simultaneous statements in oral or written form are not admissible to contradict or modify the written agreement. The reason for this rule is the written agreement is presumed to be the best evidence of what the parties intended. If they had intended otherwise, then they should have included it in their written agreement. However, if the written agreement is incomplete or ambiguous or lacking in genuine assent, then outside evidence is admissible to explain the meaning of the written contract. The rule also provides that written or oral statements that were made after the written contract was formed are admissible to the extent that they demonstrate a contract modification.